You scare me. That's what the judge tells a man with multiple robbery charges across 2 states, and this is just the first case of the morning.
You are wanted out of the state of Nevada, specifically Clark County, for a robbery. And you are asking me to set you a bond. Is this right? Okay. I don't know anything about you. I'm now getting to know you for the first time, so I don't know. My primary concern is, are you a dangerous person? Because, I have so much drama in my life right now. It's ridiculous. I just don't need any more. And what I don't want to do is release you if you are a danger to my public, because I cherish that, right? I don't need any more. So we're going to find out a little bit about you, and then we'll see where we go from there. Amy, let's get to know Mr. Jefferson.
Yes, so he's wanted in Clark County, Nevada for conspiracy to commit robbery, and theft value over 100,000 or greater. The state's opposed to a bond at this time. He, as the court knows, he's being held. Well, he's not being held. He's made bond also on robbery threats in the 228th and reckless driving.
He has another robbery here?
Yes.
That's local?
Yes, it's a robbery threats in the 228th. It is open. He's made bond on that.
Okay.
So you got a robbery there. You pick up a robbery here too. It's a robbery.
This warrant was also issued December 18th, very recently.
When was bond posted, if you don't mind on that?
Yeah, let me look.
He's actually he's on bond. He's on bond for reckless driving.
Okay.
Picks up a robbery here in September. So I guess he's on bond for a robbery here. And now he's picked up another robbery in Nevada.
I thought the robberies in Nevada were old.
He
Oh,
made
she said they were just issued 12/18.
He made the bond for the robbery threats on September of this year. That case was filed also September of this year. And then this new warrant was issued this December. His reckless driving was,
What court is that out of?
that was the
28th.
28th.
No, the reckless driving.
Oh, this one's out of court 10.
What's the court date on that?
That is
January
on January 30th.
He has a general order bond on that.
Yeah, he's made bond on that one. He also has made bond on the robbery.
And he's made court, has he made, my question is, if he's made his court appearances, Your Honor, I mean, I think he's proven that he should go on to court, showing up to court. So if you did consider bonds, he could then, don't worry about the reckless driving.
The state also wanted to add that he was just barely out of parole from earlier this year.
He was what?
Barely out of parole from earlier this year, as they have.
Who's he on parole for?
That I don't know exactly.
Mr. Jefferson, I got to be frank. You scare me, man. You continue to pick up cases, and they're serious cases, right? Second-degree felony. I don't know, maybe this is a third degree, but nevertheless, you have a robbery here, you pick up a robbery over there. That scares me. If I let you out, are we going to get a third one? I don't want that to happen. I know you're telling me no, but history tells me otherwise. All the open cases tell me otherwise. Now, I do have some good news for you. The good news is that you've made bond on these 2 cases here, so there's no holding pattern, meaning that Nevada has 14 days to come get you, and if they don't come get you, then Harris County releases you. So you have that going for you now, but I just don't feel comfortable giving you a bond. You scare me, man. The last thing I want is a third robbery. Do you understand? You got to understand from my perspective, I don't know you. You're telling me all these gumdrops and rainbows and bunnies jumping in the woods, but you've got all these 3 open cases. They're serious. Sorry, I can't, just.
Okay, he signed on Monday, Judge, so I guess,
So.
can we reset it to, what is that, the 8th?
Days, right, Monday. So 1, 2, 3 days have passed. So you got another, 12 days, give or take.
So can I get a reset
2,
for the
3, 4,
8th?
5.
Is that correct? If I'm counting it?
The 7th.
The 7th, even better. Okay.
Yeah, so you said the 23rd?
He signed on Monday, the 23rd, is my understanding. So I think the 7th.
Yes, the 7th.
So if they don't come get you on the 7th, you'll be released in Harris County.
So they have until the 6th to come get you, okay? If they don't come get you by the 6th, then on the 7th, you'll be released. But you got to understand, even if we release you, that warrant will eternally remain open. And you could get picked up again the minute you walk out of custody. If you do get out, I would immediately go back to Nevada, take care of that. Otherwise, at some point, you're just going to get picked up again, and it's going to continue to happen.
You can hire an attorney.
And the other thing is that, right, when you do go up there, you got to let your attorney here know what the plans are so that you don't get revoked upstairs here, because then you're going to be in the exact same situation over there like how you are here. You understand? So if you go over there to Nevada and try to handle things and they put you in custody and no one knows about it here in Harris County, you have not advised your lawyer, they may think that you've just jumped ship and they might revoke the bond here, and then they'll place a hold here in Harris County because you're in Nevada. And if nobody knows, you know what I mean? So you got to let your lawyer know here.
You're a misdemeanor lawyer on your rec. Do you have a lawyer for both of them, or were you appointed lawyer? Okay, so you need to tell your lawyer that if they don't pick you, you need to contact him, and let him know you're in custody.
He has a lawyer in the felony, so
Yeah.
let your lawyer know in the felony
You let
case.
them know, and if they don't pick you up, you need to hire someone in Nevada, try to get you bonds on those, or you're gonna have to go out there and address them and turn yourself in and then see if they give you a bond.
All right.
So if they don't revoke your bonds here, you need to let your attorney know. You understand all that? All right.
Okay, man. Good luck.
Thank you, Ron.
Thanks, Ray. Thanks, Amy.
I think that's all I have. So see you tomorrow, man.
Yeah, for sure. Dustin, ready?
Sorry.
Yeah.
All right, who do we have here?
Drake Simmons judge. It's
Summons Simmons.
fugitive case.
Good morning, Mr. Simmons.
Yeah, I talked to Day, judge. We have a agreed bond of 5,000.
Okay. So, Mr.
Yeah, he just said that, you know.
You are wanted out of the state of Louisiana for a second-degree battery. Your lawyer has agreed with the state, and you are in agreement, Amy, right?
Yes, Jay is unopposed to a 5K bond.
Okay, I will set your bond at $5,000 today. You have to understand that this is the only time that this is going to happen. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. If you do that, this fugitive case against you gets dismissed. If you fail to do that, I'm going to issue a nationwide warrant for your arrest. I'm going to put your bond at 0, and it's not going to happen again. It doesn't matter what the excuse is. You have to go turn yourself in, and we're giving you enough time to do it. Do you understand? Now, the only other thing I'm going to advise you, don't wait until the last day to go, because as Murphy's Law dictates, what can happen will happen. Something invariably always happens when you go on the last day. Don't do it. As soon as you get out, make the plans to make it up there. Understand? Okay, I got you. We'll set the bond at 5,000.
He needs to have his paper withdrawn and then also.
Yeah, it appears that he is waived, so he needs to withdraw that waiver.
Okay.
Understand, by withdrawing the waiver, you lose the time that you have by that. But in the event that he's unable to make bonds, I don't know. That's why.
I'm getting.
Okay, of course.
This is. I'm not waiting for you. Wait for him.
Should I go to court 10?
I should be able to. I will talk.
Well, I don't,
I think it goes, just go back to the court.
okay. Good morning, Mr. Rodriguez. Sir, you were charged with assault, bodily injury, and criminal mischief. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You're facing up to a year on both of those cases and/or a $4,000 fine.
Judge. On December 24th, 2024, the officer was dispatched to the location and made contact with the complainant. The complainant stated that he followed the sister when she left the house to try to get her to come back. That's when the complainant ran into the defendant, the complainant's sister's ex-boyfriend, and told the defendant he could not be around his sister. The defendant walked up to the complainant really close and the complainant pushed the defendant to get some space, and the two then began to get into a physical altercation. The complainant stated the defendant bit the complainant's left arm in between the altercation and then ran away. The complainant complained of pain and was advised by EMS to get stitches, and then the defendant was ID'd with mobile APHIS.
You said this was a sister as the complaining witness?
No, Your Honor, the sister was the ex-girlfriend of the defendant. The brother was the complainant.
Got it. Okay. Tell me about the criminal mischief.
On the criminal mischief, on December 18th, 2024, the officer was
So same day.
Same day, Your Honor. No, it was before. The assault was on the 24th, the criminal mischief was on the 18th. So on the criminal mischief on the 18th, the officer was dispatched to a residence in Harris County, Texas in regard to a disturbance. The officer made contact with the complainant, who stated that the defendant broke his window with a rock. The officer made contact with the witness, who stated that on the 16th, he observed the defendant throwing a rock at the front window, breaking it. The defendant was then observed by the witness leaving the area, returning to the side of the house, and throwing a bigger rock at the side window, causing it to shatter while also trying to enter the home through the window. The damage to each window was approximately $1,200.
Both of these happened on the same day, right?
No, Your Honor. The assault was on the 24th, and according to the witness, the criminal mischief was on the 16th of December. So the criminal mischief occurred before the assault.
But I'm looking at the information. The information says December 16th on both.
There is a second assault, Your Honor.
What?
There's one.
On the 31st.
Yes. Oh, okay. My apologies. I was reading because he was just picked up an assault. Let me read the assault that's out of the same transaction, Your Honor, because he picked up another assault, and that was my apologies. So for the assault on the 16th, the officers were dispatched to a Walmart in regard to service for a disturbance. The officers detained the defendant, and a search of his person revealed 0.68 grams of meth in his right pocket, and the defendant was taken back to the original scene, and the officer spoke to the complainant, who stated that he went looking for the defendant because he was a person of interest in a previous incident. While waiting for police to arrive, the defendant tackled the complainant to the ground and held him in a rear chokehold for approximately 10 seconds, impeding his breath. The complainant stated he felt pain and suffered minor injuries to his person, including a scrape on his left knee, a scrape on his right elbow, and a swollen upper lip. A witness, the complainant's girlfriend, witnessed the incident and saw the defendant choking the complainant. The defendant also admitted to placing the complainant in a chokehold.
All right. Mr. Rodriguez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you have a problem with drugs and alcohol, you better address it, because I'm telling you now.
No, it's not a problem, sir.
Look at me. If it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. Do you understand? I'm going to test you heavily.
That's fine.
What's the name? What is your name, sir?
Mark.
Mark. Hi, Mark. Nice to meet you. I'd like to send Mr. Rodriguez for a drug test right now, please. Stop. Don't say anything.
I consume marijuana.
Stop. I'm sending you for a drug test now. I'm going to have you come back. I want to see what's going on. That's it.
All right.
But come back. I'll give you a lawyer today. I want to know what's going on with you so that we're both on the same page.
I can tell you.
Don't say anything. Stop. Stop. Go take the test, and I want you to come back. I'm going to appoint your lawyer today. As far as your bond conditions are concerned, you're not to have any contact with the complaining witness in this case, not to go where they live, where they work, where they breathe. You're not to be in possession of any weapons. Do you understand? If you violate these conditions, you know what's going to happen. You understand? All right, please. So don't worry about conditions, because I'm going to have a monitor.
Yes,
Mr.
Judge.
Shaw.
Judge.
5002.
I'm coaching on Rodriguez. He's on today's on watching.
Okay, great. Come up, sir.
And we have those results.
Great.
Judge, they represent the father for THC, amphetamine, MDMA, cocaine, and methamphetamine.
Is there something that's not, I mean, really? Stop. It's a rhetorical question, Mr. Rodriguez, but I'm going to tell you now, it stops today.
Yes, Your Honor.
We're going to do this the easy way, or we're going to do this the hard way. I am giving you the opportunity for you to try to do this on your own. If you are incapable, then you're going to stay with me, and we will do it the hard way. Do you understand?
Yes, Your Honor.
You will be required to test bi-weekly here with me, so I know that you're not using.
Yes, Your
And if
Honor.
you show me that you can stay clean, then I will stop. But we will do this in baby steps. But
Yes, Your
for
Honor.
the time being, you're going to stay here and test a lot with me. Do you understand? I will give you a pass of 45 days on the THC, 45 to 50 days on the THC.
Yes, Your Honor.
But if after that time you continue to test positive for marijuana,
Right. Yes, Your Honor.
I have given you a lawyer. It is your responsibility to stay in touch with Anna. If Anna tells me she can't get a hold of you because you play games, likewise, the bond will go bye-bye.
Yes, Your Honor.
All right? Okay?
Thank you, Judge. We'll see you on
All right,
Monday.
Mr. Rodriguez, see you Monday.
Yes, Your Honor.
Thank you. You may be excused.
Ma'am. Ma'am, you were charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 16th, 2024, officers were dispatched to a Lowe's in Harris County, Texas, in response to a theft in progress. Dispatch stated a male and female suspect had concealed items from the sales floor on the male's person, and a male threatened to hit the loss prevention officer overhead with a hammer while exiting the business. The complainant, the loss prevention officer, let the defendants exit the store and gave a description of the defendant's motor vehicle as it fled the scene. The officers made contact with the complainant, who stated he observed the defendant and the co-defendant, the male, select items off the shelf and conceal them. The defendant was using her purse to cover up items as the co-defendant concealed them on his person. The complainant confronted the defendants as they attempted to exit the business together, and the co-defendant stated he would hit the complainant with a hammer. The defendants were identified by the complainant, and the defendant's motor vehicle was searched incident to arrest, revealing several hand tools. The complainant identified items belonging to Lowe's for a total of $305.35.
Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to go to any Lowe's. Do you understand? If you violate these conditions, your bond will be revoked. It will go into custody. No more. Do you understand? Tell me, what do you do for a living? How much money do you make a month, man?
It just depends.
So are you able to hire a lawyer then?
Not at this moment, no.
That's why I'm asking you these questions.
So,
Say it again?
motor on my vehicle. So that's the first thing I need to,
How do you support yourself?
self-employed.
I need more than that.
My daughter works as well, so I don't have very many bills.
Okay, so what I'm going to do is I can give you an application, but if you just put zeros, I'm going to send it right back to you. I need to know how much money you make, how much money you have in the bank, how many cars you have. If you own a house, I need to know the value of the house. Everything I need to know. Do you understand? Okay. Do not leave until you sign our bond conditions as well, please. Good morning, sir. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 18th, 2024, the officer was dispatched to a disturbance at a residence in Harris County, Texas, and the officer met with the defendant and complainant, who are members of the same household. The officer observed no visible injuries, and the complainant stated she had been living with the defendant for 7 months. The complainant stated they were arguing in the morning, and the defendant pulled her by her legs off the couch. Complainant stated she hit her head on the coffee table as a result of the defendant pulling her off the couch, causing her to feel pain. The defendant stated the complainant had been evicted and he let her stay with him. And the defendant stated the complainant said something disrespectful, so he pulled her off the couch, but not hard enough to hurt her. The defendant said the complainant then started hitting him and he was blocking hits to defend himself.
Okay. Mr. Whittington, I'm going to find that there's probable cause to go forward with the case. Do we know whether she wants to have contact with him or no?
A rip was attempted, but there is no contact yet with the complainant.
All right. Until I know that she wants to have contact with you, I'm ordering you not to have contact with her. Do you understand?
Yes.
a protective order has been issued in this case, I would get to know it. If you violate this protective order, the state can and probably will file additional cases against you, including a violation of protective order, which is one of the worst cases you can pick up. Just don't have any contact with her and everything will be fine. Do not pick up a new case. Do you understand?
Understand.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Ramona, sign a reset, and then after that, you're on your way. All right? Please, sir. Good morning.
Morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On December 18th, officer was dispatched to a driver asleep behind the wheel at 1219 Shepherd Drive. Upon arrival, officer observed a red van with the ignition on and running in a parked position in the middle of the roadway, sitting in front of the railroad tracks. Officer woke up the defendant and observed slurred speech and red glassy eyes. Defendant stated he had left a Christmas party at Club K9 and had consumed multiple Michelob beers. SFSTs were conducted, 6 out of 6 HGN, 5 out of 8 walk and turn, and 2 out of 4 one-leg stand. DIC was read, defendant consented to breath, 0.127 and 0.127, no criminal history.
Got it. Do you see if he has a valid Texas driver license? Do you
I
mind?
can run it now, Judge.
Please. Mr. Miller, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you test positive for drugs or alcohol, your bond will be revoked. You will go into custody. Do you understand?
Yeah.
You have a lawyer. Because you have one, we will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel. If he comes back and tells me he can't get a hold of you because you're playing games, you're ducking and dodging phone calls, I will issue a warrant for your arrest.
And license is valid, Judge.
As long as you have a valid license and liability insurance in your name, you may continue to drive, but just be careful. If it does get suspended or if you don't have insurance, you're not allowed to drive.
Yes.
We good? Okay. Questions?
No questions, Your
All
Honor.
right. So I'm going to have you guys meet with the coordinator in court 6, and then you guys are good to go.
All right, thank you, Judge.
All right, guys. Happy tidings. Mr. Coleman, how are you, man? Looks like you are wanted out of the state of Ohio for robbery in the 2nd degree.
Iowa, Judge.
What did I say?
Iowa.
No,
You're close.
sorry, Iowa. Well, not really close. Are you waiving formal extradition, sir? All right, sir. We wish you the best of luck. Thanks. Good morning, ma'am. Ma'am, you were charged with 2 counts. You're charged with possession of a controlled substance. You're also charged with theft. Looks like you guys have worked out an agreement where they're going to dismiss the, is this what you want to do, ma'am? You need to understand that this is a very important thing, that you're making a lifetime decision today that this theft will go on your record. It's going to be there for the rest of your life. You sure you want to do this? You're giving up a lot of rights by entering this agreement. You give up the right to a trial, the right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, there's no turning back. It will stay like this forever. You sure you want to do this? All right. How do you plead to the offense of theft? Guilty or not guilty? I'm going to find you guilty, sentence you to 3 days in jail. I'll give you credit for the 3 days that you've done. I'll roll your court costs so you won't owe anything. Good luck to you, man. Thanks. Thank you, Aaron. Ma'am, we need you to come back. I do. All right. Good morning, Ms. Franks. Ma'am, you're charged with failure to identify oneself as a fugitive from justice. You're facing up to a year in jail and or a $4,000 fine. Probable cause has already been done on your case. Your case is nearly 300 days old, and it's time to do something with this case. Do you have a lawyer today?
Yes.
Who is it? She has not signed in on this case. Is she going to be here today?
She's supposed to, Your Honor.
Okay, so just go ahead, take a seat for me. We'll wait to see if she says it, ma'am. Okay? All right, do not leave. Good morning, sir. Sir, you're charged with assault of a family member. Your case is 662 days old. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On March 5th, 2023, officer dispatched to a residence in Harris County, Texas, and met with the complainant, who said she had been dating the defendant for 4 years. The complainant stated the defendant had been drinking a lot and noticed his driving was unusual, and told the defendant multiple times to switch so she could drive. The complainant and the defendant switched, and while she was driving, they got into a verbal argument, and the defendant hit the complainant on the right side of her face, causing pain. Once they arrived home, they got into another argument, and the defendant started throwing the complainant's clothing and belongings out of the window of their apartment. The witness was in the car with the complainant and saw the defendant hit the complainant on the back of the head, or on with the back of his left hand on the right side of her face 1 time.
Okay. I'd like to redo the protective order. Listen, one was already entered. Do we need them to do a new one? Mr. Harris, I'm entering in what's called a magistrate's order for emergency protection that identifies the complaining witness in this case. She is now a protected individual. You cannot communicate. You cannot do any family violence, assault, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon, go within 200 feet of where she lives or where she works. Do you understand? If you violate this protective order, the state can and probably will file a violation of protective order, and it's one of the worst cases you can pick up. Before you leave, you need to get to know this protective order so you don't violate it. I am ordering you not to have any contact with this person and not to be in possession of weapons throughout the remainder of this case. Do you have a lawyer today? We're giving you one today to figure out what's going to happen with this case. Your case is 662 days old, and we set cases for trial at 180. So we're going to figure out what happens with this case. I'm going to have you, well, for now, we'll just have you take a seat in the jury box. If you can reach out to the MAC, please. Good morning, sir. Sir, you were charged with driving while intoxicated, first offense. It's elevated to a Class A misdemeanor because of the high blow, so you were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 18th, 2024, the officer was dispatched to 3800 Southwest Freeway in Harris County, Texas, in regards to the defendant's motor vehicle hitting another motor vehicle and keep going. The caller stated the defendant's motor vehicle's tire fell off and that the motor vehicle was at a strip center parking lot. The officer observed the defendant's motor vehicle facing the Southwest Freeway frontage road and partially on the curb, leaned against a hedge. The officer observed the engine running, the defendant's vehicle in drive, and the left front tire shredded. The officer further observed the defendant sleeping, slumped over the steering wheel, and a strong odor of an alcoholic beverage, bloodshot eyes, slurred speech, and the defendant, upon waking, had poor balance requiring the officer's assistance. The defendant stated he consumed 2 mimosa beverages and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and consented to breath. The results were 0.169 and 0.162.
Got it. Any prior DWIs and
No, Your Honor.
license?
Eligible.
Okay. I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using, I'll put you in jail and I'm going to revoke your bond. Do you understand? What do you do for a living, sir?
I currently don't work. I got assaulted recently. I lost my job.
Where were you working? What were you doing?
I was a Uber and I worked at a restaurant.
Why stop? You still need money. How are you getting money?
I had to do light recovery.
Okay. Did you want to apply for an appointed lawyer, sir? You're going to go hire a lawyer.
I can't afford one. I need a.
That's what I'm asking you. Did you want to apply for an appointed lawyer?
But I will. No, I'm not.
Do you want to?
Yeah.
Okay. If you mind, I'm going to give you an application. I need you to fill it out. I need you to fill it out in its entirety. I need everything. I need to know everything about you. I'll take a look. If you qualify, I'll provide you with a lawyer today. Does he have you said he has a Texas driver license,
I
right?
see an eligible license, Your Honor.
You don't have liability insurance, then you're not allowed to drive. That's car insurance. If you don't have it, don't drive. I'm making that a condition of your bond. You must have a valid Texas driver license and liability insurance in your name. Do you understand? Okay, I'll have you fill out the application, Stephen. I'll have you sign a reset, and then we'll have you take your seat in the jury box. No alcohol, no dope. After you're done with that, you'll meet with pretrial services, so they'll go over your bond conditions, all right? Good morning. Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 16th, 2024, at approximately 12:48 a.m., officers were dispatched to a major crash at the 6100 block of Ridgemont Street in Harris County, Texas. Upon arrival, the officer made contact with the other officers who had advised that when they arrived on the scene, the defendant, the sole occupant of the motor vehicle, had crashed into the ditch. Upon contact with the defendant, the officer observed the bloodshot, watery eyes, slurred speech, and a strong odor of an alcoholic beverage. An inventory search of the vehicle revealed 1 bottle of whiskey under the front passenger seat, which was 2/3 empty. Standard field sobriety tests were attempted, HGN 6 out of 6, the walk and turn was refused, and 4 out of 4 on the one-leg stand. The DIC was read, but the defendant refused. A blood search warrant was signed and executed.
Can you run his criminal history, please? I'd like to see if he has any other DWIs.
Your Honor, there's no prior DWIs.
Is there an allegation that he was allegedly consuming alcohol while he's driving?
No, Your Honor, they only found a bottle under the passenger seat, not cold to touch or anything like that.
Mr. Nesbitt, I'm going to find that there's probable cause to go forward with your case. Have you run his license to see if he has a Texas driver license?
It's eligible, Your Honor.
All right. I'm ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go to jail. No more PR bonds. Do you understand, sir?
Yes.
Okay. You have a license. You're not allowed to drive unless you have car insurance as well in your name. I'm making that also a condition of your bond. Do you understand?
Yes.
Do you have the ability to hire a lawyer, sir?
I'm sorry?
Are you working? What do you do in life?
I'm a mechanic,
What
but
kind of
I
money?
can afford an attorney.
Do you want to apply for an appointed lawyer, sir?
Yes.
Okay. We'll give you an application. I need to know everything about you. Don't just put zeros because I'm going to send it right back to you. I need to know everything about you. And if you qualify, we'll appoint your lawyer. But just remember, don't consume alcohol. Don't use illegal drugs. You understand, sir?
Yes.
Okay. Stephen will give you the application. I'll have you sign a reset with Ramona, and then we'll have you take your seat in the jury box, sir. Did you want to talk?
Yeah, Judge, I've got a case, Derek Adams, on the docket. He was supposed to complete 2 classes by today.
Not do it?
No, he did,
Right.
but he didn't pass one of them. And the contract doesn't require passing, it just requires taking. And so, Miss Saba, hey,
Judge,
we
I
have some
just-
contracts.
I just needed chief approval that that's sufficient. I've never been in this situation. Like, I don't know if I can dismiss a case for failing an effective decision-making
Okay.
course, but
How do you
attempting
Get
it.
this, Judge,
Really?
there's not a single chief working today. So it seems like there's not really effective.
So let's roll it to
decision-making
tomorrow.
going
Have
on in
him
the
take it again.
I'm not coming back here.
Zoom in. That's why I have Zoom, to make it easier for you.
That's true. I'm appointed. Money's really tight for him. The
Case
contract
is 1,292 days old. We've given him how much grace to get this thing done over and over? Really?
And it was
Judge-
just 2 classes, Judge.
Last time, if you didn't have it done, you didn't have it passed. I'm carrying you day for day.
The contract doesn't require passing. I mean, I'm actually serious about that. Although it's funny.
I would be hard pressed to find a chief that's going to acquiesce to that. I mean, really,
I mean,
I don't know.
It was just, it was a pretty good PTI offer, Judge. It was just effective decision-making and a gun safety class, both of which are 2 hours. The effective.
Yeah, it's a
decision-making
2-hour class, right?
Costs
Corey?
$22, I believe. There's no reason he shouldn't be able to do it again.
Just, you know, a lot of times they don't take it seriously. So let's roll it to tomorrow, have him do it again, and then let him know we're going to redo it day for day until he gets it done. At nearly 1,300 days, I have no sympathy for this person.
what's the term? A collateral estoppel or something like breach of contract? It's not my bag of chips.
Remember, they're the ones that have the power to dismiss. I don't.
Right.
They're the ones, I just sign it. They're the ones who actually file the motion.
I know that.
So do we know
I'm just
when is
asking.
she coming back?
I mean, Kelsey won't be back till Monday, Judge.
Okay, so let's roll it to tomorrow.
Yeah.
Have him take it again. Maybe he'll pass it this time. Tell him to pay closer attention. It's only 2 hours. It's not much. If he doesn't want to do it, okay, I'm just going to roll into Monday. I'm going to keep doing it. It's 1,300 days. We got to take care of this thing.
As long
I'm
as
gonna
I
set
have
for
a
trial.
chief tell me that the attempt is fine, like I just can't make that call, Judge.
Did you see how good of an attempt it was?
He failed it. It was like a 50%.
Somewhere around 57.
So
I'm rolling it to tomorrow.
is there a possibility that we're gonna have a chief?
No.
As long as there's another
not one
chief.
But if he passes, it gets dismissed.
Yeah, and I can ask another, like, if our bureau chief is here or one of our deputy dogs, I can go ask them after docket, Judge.
It's up to you.
Oh, I've been around everywhere. There's no chiefs.
Well, I mean, they would be on the 5th floor, Judge.
Yeah, well, regardless, I mean, we have a lot of work to do. We have 3 other courts that we need to cover as well.
Yeah.
So have him try it again tomorrow. If he doesn't want to do it, then we're just going to roll till Monday. Yeah, really.
Is Diane here?
He's here, yes.
Adams?
Come on up.
How you doing?
Hi. Hi, Joe.
Hi, Judge. Nice to see you.
Merry Christmas, sir.
Merry Christmas to you, Your Honor.
What are you doing with your client?
Yeah, yes, sir. I did talk to him about the most recent offer that came in this morning. And the VA's not here, so I can't really respond back to her on some evidence. So we were going to go on.
Judge, she emailed me this morning. She's looked at the mitigation packet that defense sent, and she emailed me this morning telling me what her offer is. So everything that I relayed to her is her latest update.
What is the offer?
It's a 9-month deferred, Judge.
Yeah, and Your Honor, one of the things is, just from reviewing this, it doesn't appear that the mitigation made clear enough, or they didn't take very seriously the statement that the house that the complainant and her mother's living in right now is owned by my client. He's the owner of that house. And they are living there because he's allowing them to live there. Now, he's charged them rent before, but he has not moved to evict them. He wants this process to end. But somehow from the notes that they were reading.
What's your client's name? What is your?
Hudlow.
Hudlow.
Hudlow, H-U-D-L-O-W.
Yeah.
And
the problem is that it's really old.
Your Honor, and I discussed that with them. And so they're willing to keep, he wanted to talk to Mr. Garza directly. I've been back there calling for the last 30 minutes, if not longer, trying to reach him.
What we can do is I can give you till Monday, but it's plea or trial on that day.
Yes, sir.
You know,
That'll be-
Mr. Hudlow, come up.
And Judge, the state's offer is gonna stand. I mean,
Come
Morgan,
around this way, sir. All right. Good morning, Mr. Hudlow.
Morning. Merry
You
Christmas.
got to understand reasonable minds can differ. Just because you want something a certain way doesn't mean that it's going to happen. In life, it goes like that in every aspect. You know, when you're buying a car, when you're buying a house, whatever it may be. You know, he can't control the offers as they're going to give. He can only tell them merely what, you know, he is given a certain set of facts and he has to work with those facts. Sometimes they're good facts, sometimes they're not so very good, but it is what it is. Now, our case is old. It's 210 days old, and we set cases for trial at 180 days, and I have no idea how this got to be as old as it is now, but it's time to make a decision. Now, your case, they have offered you a 9-month deferred, which is a type of probation that if you successfully complete, you do not end up with a conviction on your record. You can't tell people it was dismissed because it's not dismissed. It's merely a probation that you took. If you complete successfully, you don't end up with a conviction, right? But that's the offer that they've made for you, and it appears as what the state has said, that it's going to stand. Look,
You're happy with that, I'm sorry.
you don't have to make a decision today. If you want to make a decision today and you want to be done with it today, we can do that. But I can give you one final setting to Monday. If there's other people that you want to talk to, it's up to you. But it's time to put this baby to bed once and for all. So I will give you the opportunity now to talk to Joe to see if that's something that you want to accept now. If you need a little bit more time, I can give you until Monday. But at that point, you must either accept the plea bargain agreement or I'm going to set your case for trial because it's just too old.
I haven't had a chance to talk to Eric. Can we set it for Monday?
Okay.
I'm not saying that,
No, look,
Actually, I would go
you
with-
don't have to say anything. I'm happy to do that, but you get no more resets after that day. So if you're unable to get a hold of him or whatnot, I don't care. You need to be diligent in getting together with Eric to figure out what you guys want to do with the game plan. Take a look at all the evidence, and then you make an informed decision at that point. But there's just no more time after that. All right?
Yes, sir. Yes, sir.
And I'm sure that Joe can try to get you, help you get with Mr. Garza, okay?
Because I don't know with his vacation schedule, I don't want to put anybody out, but that's kind of how I think we ended up here.
We have too much.
Thank you,
Okay.
sir.
All right, guys. Good luck.
Thank
you, Joe.
Thank you very much.
You ready?
I'm ready.
All right, come on.
Mr. Vanderslice.
So this is with,
No, it's not it.
it's without an agreed right?
Yes, I told him to put it up there,
Okay.
and these are the enhancements, they said to abandon those two that are to the bottom. Just the, and it was 180 days, probably different.
So
Yes, Judge?
but he had an open container of alcohol in the car too, though?
Yes, the surveillance shows that he hadn't been driving from 8:15 to 11 PM, and the car was also smoking at the time they.
Tell me what happened in this case, because I don't know anything about it.
I can.
I mean, if defense.
No, but I want, please, read to me the dims.
Okay, Judge. My computer's been slow today, so my apologies.
It's okay. I want to know that I'm making the right decision. Mr. Vanderslice, I take public safety extremely serious. I don't care who you are. I don't care what color you are. I don't care if you're a small farm animal. My only concern is public safety, and if you leave a wake of death, that's just not a good thing, and now you've got a DWI. They're saying that there's a prior DWI. You've got alcohol in the car as well. I mean, when do we say when? Now, I don't know specifically what happened in your car. I'm just looking at the allegation here.
Prior DWI, the judgment on DIMS
So,
or
one of-
NCIC is incorrect.
Well, one of them was reduced to a reckless, Judge, and the other one in Dallas was dismissed because he was convicted of murder.
So
And
this
that
is, it's a third DWI.
It was, yeah, the other one was unrelated.
Go ahead.
On June 7th, 2024, officers were dispatched to the Circle K parking lot where they were advised of a white GMC Sierra. The officer observed the car partially in a stall, and the defendant was the driver and lone occupant passed out behind the wheel. The car was running and the defendant had his foot on the accelerator. The vehicle was in park. The officers woke the driver, who was extremely slow and lethargic, had slurred speech, watery eyes, a strong odor of alcoholic beverage, an unsteady gait, and had to be guided back to the patrol vehicle. 2 bottles of Crown Royal Apple Whiskey were located in the car. One was empty and one had a little bit left. The defendant said, "I'm not going to do anything to incriminate myself" when asked to do SFSTs. The DICs were read and a search warrant was executed and blood was drawn.
There should be a additional part to the probable cause that talks about the surveillance now.
I'm going to give you opportunity to say your piece, but so initially with this case, you went up and they had offered 270 days in jail.
365.
It was 365. And the reason is because you have a murder case. There was a prior murder case. Did you do time in TDC because of it?
Yes, sir, I did. I did 6.5 years on a 10, and they let me out for good behavior.
Okay, no, that's, and then not only that, but we have 2 prior DWIs as well. One was reduced, one was dismissed pursuant to the plea bargain agreement. So
2010, I think. 27 was the date of the offense, murder, the case that he had. And then that had nothing to do with the DWI.
The DWI was in 2009.
I sent a letter to everybody explaining, our agreement from before, which was a 2-year probation based on having looked at all this stuff. And then they re-looked at it and they said that they would be fine with the TRAS recommendations. But the reasons why I think they tripped it up is it looks like the murder and the DWI were at the same time roughly, but not part of the same transaction. So the DWIs had nothing to do with anybody dying. That was a sort of a bad.
Sure. I mean, so while he's on bond for DWI, picks up a murder case, or is it vice versa?
Murder, he picked up a DWI case, I think is the, but it was at his aunt's funeral. And the problem is because he's been convicted of murder, the girlfriend wouldn't let him stay at the house, and he had a hotel. His wallet got stolen, so he was sleeping in the parking lot. And that's when he drank, when he went to sleep. If you look at the offense report, it does fill in a supplement after Mike and I talked. The officers went and looked at the surveillance. The surveillance, his car is not functional, and at night the lights don't work. So he had to park before it got dark. He couldn't stay at the hotel. He parks in a parking space at the convenience store, drinks, falls asleep, gets up to go to the restroom at like 10:30, which is 2 or 3 hours later. So the car doesn't move while he's drinking his apple crown. The car doesn't
Do
move at all.
you have that on video so that we can
That's on
verify
video
that?
surveillance.
Have you seen that?
I believe he looked at it with Kelsey. Is that what you
I've
said?
looked at it and it's in their stuff, but it's also in the police report. The officers looked at it and they put it in the DIMS as a supplement.
You take a look?
Yeah, at least the DIMS I read. So, and it says from 8:15 to about 11:03 when they came there that he did not drive his car. And that's when he says he sat in the parking lot and drank the liquor that he bought at the liquor store before 9 o'clock, obviously. And
So you're telling me that he pulls up to a liquor store?
he pulls up to a convenience store.
Convenience store.
Correct. And
buys the whiskey
buys some whiskey
at
because
Circle K?
no, it's a different store. So he pulls up the liquor store before 9 o'clock. Then he pulls up to the Circle K at 8:15, I believe, or
Sure.
8:30.
So how do we know he's not drinking?
So Judge, the supplement says that officer also swore the video at the Circle K shows the defendant entering the parking lot of the store in his motor vehicle at 8:20 p.m. on June 6, 2024, and officers arrived on scene at around 10:50 p.m. on the same day. So they see him driving into the parking lot.
How do we know he's not drinking before he pulls into the parking lot?
Well, that's why I'm pleading. But, that's part of the reason. Obviously, his car doesn't move for the time he's in the parking lot. But he told me he bought the drinks before when he found out he could no longer be in the hotel. And that is because his lights didn't work due to an accident that his car had. He had to shut it off before it got dark. So he parked, he had nowhere else to go.
So there's no accident in this case?
There's no accident in this
Judge.
case, no. He had nowhere to go because of the murder conviction. He can't stay with his girlfriend when she has her kids.
Are you still on parole now?
No, sir.
Yeah, it was a 5-year offer from the state. It had to do with a roommate and a fight, ironically, over he was trying to prevent the roommate from driving intoxicated. But it not really a roommate, but it was a guy who was.
So do we really have to abandon the first paragraph, right? Because he said that in the Panola County, that's not a DWI conviction,
Yes,
correct?
Judge, that's
Yeah,
correct.
Okay, so let's abandon the first paragraph. The second paragraph, are you wanting to abandon as well? That would make it a mandatory 5-day minimum if we don't abandon.
Yes, Judge, and because we agreed, we came to you without an agreed rec, and we said that we would do what TRAS
If you
recommended.
plead true to this first paragraph here, that would make it a 30-day minimum.
Which paragraph? Yeah.
The murder,
No, I think the intent was to abandon that one.
Yes, Judge, so
abandon all three.
not the last one as well?
Yes.
That would make it a mandatory 30-day minimum.
Yes, Judge. I don't.
All right, Mr. Vanderslice, what you're doing now is you're entering into an agreement with me and you want me to punish you as far as pleading guilty to this DWI conviction. You need to understand that this is a lifetime decision that you're making today, that once you plead guilty, there's no turning away. You give up so many valuable rights. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charge read in open court. If you're not a citizen, or you can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you plead guilty, you can't take it away. You have not been able to come up to an agreement with the state. The only other option is to either set up for trial or come to me if they waive that the ability to go to trial and to come to me for punishment. And they have agreed to do so. Do you want to come to me for punishment?
Yes, sir, I do.
Okay. How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Well, I'm pleading guilty, sir.
Okay. I'm going to find you guilty. The idea is that, how old are you? You're 52.
Sir.
When does it stop? At what point do you learn? At what point do you say, I can't, I got to stop? How much money has it cost you over the years? How much time has it cost you over the years? I can't.
And I totally agree with you. And I have stopped, and I am done, and I am stable in all directions at this time, and plan on staying that way and not disrespecting your county at all anymore. And you never see me again in this courtroom.
Everyone says that.
No.
The thing is that words mean nothing today, man. I get it that maybe in 1890 business was done on a handshake, but handshakes don't mean squat now, because people now, they don't think of consequence. They act without thinking, if I do this, what's going to happen? If I say this, what's going to happen? They just act. They shoot first, ask questions later. And in life, you got to know when to say when. Shit is always going to happen in your life. You're always going to step in shit, right? But the idea is that you scrape it off your boot and you walk on, because it's going to constantly happen in your life. Something is always going to trip you up, whether someone dies, whether you lose your job, whether your wife cheats on you. It's always going to happen. But the idea is to figure out how to cope, how to deal with it, how to deal with the anger when it comes to you, because you're going to get angry. This agreement that you're getting with us today, you're pleading guilty to 180 days in jail. I'm going to put you on probation for 2 years, so I've got you next to me for the next 2 years.
Yes, sir.
And what we want to see is, how do you deal with the anger? How do you cope with the loss? Because it's invariably going to happen, whether you lose your pot, your mom, your girlfriend, someone cheats on you. That's how we need to cope with it. I got to imagine prison must have been one of the worst experiences ever, was it not?
Sir, I was raped in prison.
And yet that now we have more, it sucks. Prison's not a great thing. It's supposed to be bad. It's supposed to teach you not to come back.
I'll never be back again.
I bet you said that when you pled to the murder case. How much do you want to bet you said that on the murder case? I'm trying to make a point.
Sir, I understand.
The point I'm making is, how do we reach you so that when you get angry again, when you get hurt again, you don't reach for a bottle, you don't reach for some kind of hardcore drug, get into a car and kill someone. All I'm asking you to do is don't take another life.
I will have the proper coping skills for any type of anger that comes in my direction for any reason.
I would say he's done a few things while being out on bond to show that his words are backed up with actions.
What has he done?
He hasn't tested positive. He's blown in the machine. He's
That's good.
Sort of
That's great.
put his life together. He's actually off. His doctor has changed his medication because of the quitting drinking has helped him with some mental problems. He's noticed that he's sought out help. I think he's working on an IOP and he's done a lot while on bond, but mostly just stopping and seeing what his life turned into after he stopped, and he sort of likes it. And yeah.
That's all we ask. You know, I every single person that comes up here, $40 to $50, one button. Wherever you want to go, Uber will take you.
Right.
You know, I routinely take, when I go out with my wife, because I like to drink,
Yes, sir.
I take an Uber everywhere. So I know I don't end up on the other side of this bar as well. As part of the agreement between you and I, you will be doing a repeat offender DWI education class, thinking for a change, 4 victim impact panels. No drugs, no alcohol, substance abuse treatment. There is a no breath test refusal. So if you are pulled over in a car and an officer asks you to submit to a breath test, you must do it.
Yes, sir. I have a lifesaver in my unit.
But if you get pulled over and an officer asks you, that's what I'm trying to say, you have to submit to it. You must maintain a guardian interlock, no drugs, no alcohol, a $150 one-time donation to Mothers Against Drunk Driving, intensive outpatient treatment followed by supportive outpatient treatment.
Sure.
Thank you for being so forthcoming. Not everybody is, and I truly appreciate it. And all we want to do is help as much as possible. And that's all it's what we like to do. We want to see you succeed, believe it or not. We want you to, walk out of here leaving better than you came. That's the idea. So that in the future, when you're confronted with these issues, you think before acting. That's all we're asking.
Sure.
All right. Do you have anything else that you guys wanted to add?
No, Judge.
Okay. Anything else?
License suspension or?
Say it again?
License suspension or?
No, because it's a true first, right? It's a true first because the first one, so I'm not going to suspend the license now. I want you to understand though, is that if I find that you drink, I'm going to put you in a rehab facility. There's no ifs, ands, or buts. I don't care if you're kicking and screaming and you got George coming up here just bitching and hollering. I don't care. If you consume, and I don't care where it's coming from, I'm going to put you in a rehab facility. If you violate this agreement, I will issue a warrant for your arrest. I'm going to put you in jail. I'm going to deem you a public danger, and I'm going to make your bond so high, you're going to go nuts. And then into a rehab facility, which is at a minimum 9 months if you respond well to treatment. Do you understand?
Yes, sir.
All right, Mr. Van der Slice, we wish you the best of luck. I'll find you guilty. I'm going to follow the agreement, send you to it. Yeah. What do you do for a living, Mr. Van der Slice?
I'm an auto broker, sir. I help people, families that are facing in Houston gain access to vehicles.
And how much money do you make a month? Okay. The reason I'm asking is because of the DPS fines and fees and surcharges.
Yeah, he's basically indigent. I mean, part of the problem was he was living in his car. So it wasn't a hotel room where he can just stay somewhere. He does have somewhere to stay most of the time now.
Jen, the state, obviously it's up to you, Judge, but the state would be willing to forego the $150 donation to MAD.
No. That's part of the agreement that's going to stay,
Okay.
right? But let me do this. Have him fill out an indigency affidavit because I want to know.
Sure.
Be honest. You're going to fill out something. You're going to swear to it. So I want you to be honest. How much money you make? If you don't qualify, then you're going to have to pay this fine. But it's spread over 2 years, so you're going to end up paying like $50 a month. So it's not expensive. But I want you to be honest on this affidavit. All right? Okay. Come on.